of Zoom, so that there is social responsibility on our part, as well as there is social distancing. That's number one. Number two, I have to apologize because initially I have asked that this press conference be physical, but for the reasons I have just stated, we have changed it from physical into remote communication, namely by Zoom. That's number two. Number three, I want to say why I thought it is important that I call for this press conference by way of Zoom to address two very critical matters. They are very new matters, but before I bring up these matters, I want to say my intention so that nobody misunderstand me. Nobody should accuse me of criticizing the judiciary, criticizing lawyers, whether legal or judicial service or private practitioners, or even the Bar Council. Because I think of late, there are developments that was brought about, necessitated by the COVID-19 rampage. You find that courts, out of necessity, has got to develop ways and means of hearing cases. So you find that there has been amendment to the Court of Judicature Act 1967. There has been a kind of arahan from the Chief Justice and various other amendments where the COVID-19 laws are specifically addressed. Now, obviously, because they are new, there can be a lot of misinterpretation. There can be divergent interpretation in relation to different cases which ought to receive the same treatment. Now, when I mention specific cases, I want to stress that it is not meant to criticize any particular judge. It is meant to demonstrate by a living example as to what can possibly go wrong or what can possibly be an interpretative development that requires a little of public debate, so that judges can also be guided, because judges are also human, so they can make errors. Two issues. One issue is, can any judge direct any solicitors or accused person or witnesses who are confirmed to be of a certain category within the MySejahtera group? Like, for instance, if you are orange and above, I mean orange right up to red, the MySejahtera classification will say that you are, at the same time, you would be confined to a quarantine of a minimum of 7 days. Normally it's 7 days. It used to be 14, now 7 days. But if you are yellow and if you are a casual contact, you can go to various places. The action that you're forbidden are very limited. You're more or less all right to travel here and there, but you've got to keep informed that your MySejahtera on a regular basis as to your temperature, as to your COVID test, whether the easy test or the PCR test, and so on. But when it comes to the court, you will notice the court has taken a more strict approach. You find in every court, there is this diagram that even if you have yellow, which is the lowest category of concern, you are not to attend the court, even if it is yellow, even if it is casual contact. So people who can enter the court are only the people with category blue. That means you are completely safe. no risk at all, you can go in. And that's why now, if you go to the court in Kuala Lumpur, there are guards that check you, right? And when the guard checks you, and if you're blue, they allow you in. If you're yellow and onward, forget it, you can't enter. So then there arise a situation. You see, I must first of all say to you why you should be understanding about the predicament of judges, including judges that I'm used to the last few days, Justice Colin Sekura, for instance, and any other criminal judges, criminal court judges, who will be quite concerned how would they adjourn matters, because either the prosecutor, the defense counsel, or other lawyers and the accused or witness have got this impediment in relation to COVID-19. So recently we have situation where Justice Colin, with no criticism on him, I mean to raise this so that courts and the public are more aware, have asked people like me, people like Datuk Seri Najib, to attend to the court in spite of our status being at that time yellow. Yeah, at that time it was casual contact but yellow, and that arose as a result of, I must give you a little bit of historical background. A few days earlier, both my son Muhammad Farhan and myself attended my son's wife's birthday party. It was a dinner, it's not even a party. It was just 2 tables at Hilton Chinese restaurant. There we discovered one person who was at my table. We won't name her. She's a wife of a very famous lawyer. The next day, she apparently had confirmed COVID. She's now a COVID patient. Now, her daughter works for me. So apart from Farhan and myself exposed to her, her daughter is continuously being exposed in the house. She comes to my office, where Datuk Seri Najib was preparing his various affidavit, various submissions for purposes of the what they call it, SRC, further evidence argument, and also to take the decision on the 7 and 8. This exposure was on the 4th, the dinner, yeah? And then my son is confirmed COVID, confirmed, yeah? He is still now in the apartment, confined alone. He has been isolated. He cannot meet with his own wife and his 1-year-old son, because they are staying with the in-laws. Now, so Datuk Seri Najib, myself, and my team of solicitors are all affected because we were all working as a team. So to cut it short, can we have a situation where judges are given discretion to say, doesn't matter about your situation and your exposure, you must attend the court? Okay, this is an important issue because we're dealing with a national situation. It is a national emergency. On one hand, lawyers are faced with this direction that once you are in that kind of contact, I am not a second, I am a primary exposure, because my son was with me. That particular Datin was almost beside me, separated by the husband in one table. And then the Datin's husband, the Dato, now is a confirmed COVID patient. So it was quite a frightening situation. So we decided to write to the court and we say, look, we take, although on the 4th, I had been exposed, I say on the 6th, I will take the cutoff date. So I will impose on myself 7 days from there. Therefore, my date of quarantine will end more or less about 15 or 16, which is yesterday or day before. So that is because there is a social responsibility, there is a direction from KKM to do that. So in the light of that, Datuk Sri Najib also has got a similar impediment. So the biggest question that we have is, while a judge can do that because he is immune, even if it is a wrong direction, let's say, he's immune because he cannot be committing an offense, and that's fine, because how can, if a judge were to act, to be acting bravely, if every now and then he is subject to a criminal sanction, then he can't function. So a judge is immune even if he's wrong, but we are not. We are not immune from the law in relation to the issue of we are breaking the regulation or not pertaining to social distancing as directed by the laws of KKM. That's number one issue. So finally, on the 16th, Datuk Sri Najib, in spite of being in a state of orange, which is an upgrade, and I will tell you why it became orange. It became worse than yellow, had to be present in court physically, and I became orange as well. And my, what they call it, quarantine period has been extended, and I'll tell you what happened. Although it's a wrong extension, but I'll tell you why, because that will be my second issue, because I think MySejahtera is very defective, not efficient, and there's a serious problem with it. That will be another issue I want to raise here. Now, so the trial went on, and I was absent because I thought I shouldn't be there. So my other lawyers, including my wife, Cik Tanya, attended together with some other lawyers who are not affected from another firm to conduct Datuk Sri Najib's case. It would have been ideal if I did the cross-examination, okay? But I couldn't do the cross-examination because I thought I'll be irresponsible if I turn up with that kind of impediment of COVID. Now, then comes to this issue of MySejahtera. I might as well say this to you quickly so that I can move on to the third point, which is also equally important. MySejahtera, I discovered this, that if you have been exposed to a COVID patient or a COVID confirmed patient, you are supposed to enter into your MySejahtera, and then you are supposed to answer the questions. There are about 4 or 5 questions. The question will be something to the effect. Let me get it for you. Can you get the, yeah? Can you get a thing? There are about 4 or 5 questions. One of the question is, have you been exposed to any COVID related person? And if you say yes, and there is no question asked, when were you exposed? You notice that or not? Okay, this is the question. Let me tell you that. First question is, are you exhibiting 2 or more symptoms as listed below? Like for instance, fever, chills, shivering, body ache, and so on. There are about 10 of them. If you say no, you move on. If you say yes, there is one problem already about you. Then number 2, besides the above, are you exhibiting any of the symptoms listed below? A cough, difficulty in breathing, loss of smell, loss of taste. These are more particular to COVID. If you say yes, your situation becomes even more serious. And then they ask you, have you attended any event or areas associated with known COVID-19 cluster? If you say yes, you have upgraded yourself towards being a COVID-19 suspect. Yeah? Number 4, have you traveled abroad within the last 14 days? And then if you say yes, of course, that's another factor. And the 5, question number 5 is important. Have you had close contact with any confirmed or suspected COVID-19 cases within the last 14 days? And the question is within the last 14 days. Bear in mind, I did my first entry on the 4th or the 6th, I'm not sure. But I think as early as I knew, maybe on the 5th or the 6th. And I answered all these questions, including, yes, I have been in contact with a COVID-19 case. And number 6, number 6 is not so relevant, whether you are COVID-19 Ministry of Health volunteer in the last 14 days. So I have answered the first time. So when I turn up in court for Datuk Seri Najib's case, I was told to turn up, show to the security guard my yellow status. And somehow or other, the security officer came out and say, can we see your status? I showed, there's yellow, clear. And they say, can you press the refresh? I press the refresh. When I press the refresh, miraculously, mine turned blue. Although I am still under quarantine. That was, what date was that? That was on the 10th. That was on a Tuesday, last Tuesday. Okay. Last Tuesday until 16 is the hearing. So miraculously it turned blue. And so did Datuk Seri Najib. But the miraculous thing is, not only both of us turned blue, but both of us turned blue at 9:36 a.m. on the dot. It cannot be, because we could not have possibly simultaneously pressed. Okay, it's a little suspicious. I don't want to say anything more because I don't want to make any untoward allegation. But that's all right. Then after our status, we have to go and answer the questions. When you answer the question, what happened is they ask you the identical question the last 14 days. So I say, of course, the last 14 days I've been exposed directly to a COVID patient. They never ask precisely when. The significance of this not asking is important, because if they say, when were you exposed? I will say on the 4th or on the 6th. Then the calculation of my quarantine will be from that date. But when I turn up on the 11th or 12th, and if you ask me the same question, the system assumes that I was exposed on the 10th or 12th, or the 13th or 14th. And then you start your 7 days quarantine all over again from that day until God knows when. So that is the weakness of MySejahtera. So today, on my status, I am still having the, what they call it, the orange, and I'm still having what they call the monitoring. They call it home surveillance, whereas it should have ended at the latest yesterday, because my exposure is only once during that period, then namely the 4th and the 5th. That's it. Okay, that is all that has got to be concerned about. So technically, I've finished my quarantine, but as of today, I have finished my quarantine. But MySejahtera says I'm still got to go quarantine another 20 days because MySejahtera is not being smart; it's calculating from the wrong date. This is the fault of the designer of MySejahtera, and I think KKM should look at it, because it is a system that is not reliable. It is a system that is unfair, and it will clog up the court cases, because even if the coming Monday, MySejahtera will still show orange when it should show I'm blue. So it clogs up the court diary, it clogs up the court hearing. And we cannot be blamed, because how do you react to a direction from the Ministry of Health through MySejahtera and a direction from the court? We just cannot break the regulation. All right, that's the other point that I want to talk about. The last point that I want to speak to you is this. Now, judges have been, because I mean, quite understandable, because this is a new act, new regulation, new system, and new situation altogether because of COVID. So a lot of judges have been misinterpreting. I'm glad Justice Collin has not misinterpreted the latest act, the latest regulation, because he said quite kindly, he said he too does not think a hybrid hearing is correct in a criminal situation. That in a criminal case situation, he said he too thinks a hybrid cannot take place. Now, you remember a recent case of the trial, or rather the appeal of SRC. That is a criminal case. We have got a hearing we wanted the judges to hear on an urgent basis on the 7th. The judges of the Court of Appeal held that they can do a hybrid. And I remember the chairman said, there is now the CJA regulations that they can use the discretion to do a hybrid. I'm here to tell you, you cannot do a hybrid in any criminal cases and in particular trial, but in the case of the SRC, they misinterpreted it, although it was an appeal. And let me read to you what the learned Chief Justice have handed down in her wise move. She has handed down on the 2nd of January 2021 what is called Arahan Amalan Ketua Hakim Negara Bilangan 1 tahun 2021. And the topic is very important. She says, pengendalian proceeding case civil. I want to stress that case civil melalui teknologi komunikasi jarak jauh bagi mahkamah di seluruh Malaysia. So in civil cases, she said, you can do this distant telecommunication, which can be by way of Zoom or by way of any other method. And she mentioned here that one of the ways you can do this is by the way of hybrid. Hybrid meaning some people are physically in court, some people are in remote. So some people are before the judge, some people are not before the judge. Now, the learned Court of Appeal judges quoted without mentioning which provision. They say, well, we can do hybrid. There is no other situation where hybrid is mentioned. It's only in this CJ direction. And I presume what they meant is Regulation 6. Regulation 6, which says this, Mahkamah setelah menimbangkan faktor-faktor di atas, hendaklah mengarahkan supaya proceeding dijalankan melalui teknologi komunikasi jarak jauh, cara fizikal, number 2, or kaedah hybrid. If the CJ direction is correct about hybrid, it only applies to civil cases. It cannot apply to criminal cases, never. All right. So I want to make that clear because I find it troubling that the Bar Council has not come up to interpret this and educate the members of the profession. It's ridiculous because this is a serious matter that pertains to the livelihood of the members of the bar. But I want to invite them politely, perhaps the Bar Council, maybe the new committee or the existing Bar Council, they could look into this and make a determination and therefore a statement like I am forced to do now. Now, so you now know hybrid cannot work. I'm going to touch on the what they call it, the this act called the Court of Judicature Act. Court of Judicature Act, which is an act of parliament. The CJ direction is not a statute, but it is a direction. That direction must be consistent with the act of parliament if there is one governing it. There is a new provision called Section 15A of the Court of Judicature Act 1964, and this act came in. Yes, it came in only with effect from the 22nd of October 2020. Okay, 22nd of October 2020. Now, And it reads this way, 15A, mind you, capital A. It says, without limiting section 15, the court may, in the interest of justice, very important, conduct the proceedings of any cause or matter, civil or criminal, through a remote communication technology. All right. And then in the case of the High Court, the place in which the High Court is held to conduct the proceeding of any cause or matter, civil or criminal, through a remote communication technology, shall be deemed to be conducted within the local jurisdiction of such High Court. That's not so important as number one, 15A1. Therefore, says this. They mention only whether civil or criminal, you can do by way of remote communication technology. There is no mention anywhere that you can mix and match, namely hybrid. Nowhere is it mentioned. So there is an interesting issue, whether a remote communication technology may include a hybrid. Because the reason why I raised that is this, because the definition of what is remote communication technology is provided in the Act. He says remote communication technology means a live video link, a live television link, or any other electronic means of communication. So where is this hybrid idea coming from? So that is my question to you, which I am inviting you to educate the public, because there is no such thing. All right. Now, that having been said, I want to tell you why 15A has been given that number 15A. 15A is immediately after 15. 15 is a concept in the Court of Judicature Act. To say something, it sounds very simple. It does not even sound very serious. But if you examine that concept, it's a very serious concept. 15 say all courts must be in open. That means it must be open court. Because we have followed the British system. Why do we need open court system? Namely, the public and you reporters can have easy access. Generally, anybody can go in, provided there is enough space. You can go in and watch the proceedings. Because a famous lawyer in England by the name of Jeremy Bentham says, open court system is important because secrecy in hearing any cases is the seeds germinating corruption. Because it is the people who attend the trial or the proceeding who will be judging the judges while the judges are judging the case. You see how important it is. So 15A attempts to make an exception to 15 because the legislature realized that if you do remote telecommunication system, this element of the court being open is limited to a great extent. Because first of all, reporters can attend, but you are put in another room. You can see the face of the judges, the face of perhaps even the witnesses, the face of the lawyers arguing, very tiny on your small screen, and you cannot access, you cannot make a judgment as to their, demeanor, their reaction, their facial reaction. Even the judge's face, you cannot see. Now, lawyers will read the judge's face because when we are debating with the judge, we can see in a physical court whether the judge likes the idea of what we are proposing or not. Just as the judge is looking at the witness and the lawyers, and they too read our demeanor, and the demeanor become part of the court proceeding. So in a remote telecommunication system, the effectiveness of looking at the demeanor of witnesses and looking at the reaction of judges and lawyers are almost zero. I would dare say 80% is gone, because I can hardly recognize the judges, except I can guess who they are, but I cannot read their face. Now, there is some other very important aspect. When you have a remote situation, say in like a Zoom, my client and I may be separated. My client cannot be in the same room, for instance. Yeah. So if you have a trial, it is a worse situation, isn't it? An appeal is already bad because I can't take instruction immediately, simultaneously as the proceeding is ongoing. But in a trial, you need instruction as the witness is making allegation. You need instruction. You can't take instruction. All right. But most of all is this. Let me tell you this because you may find this quite frightening. Why the open court system is that the accused is able to confront his accuser physically in court. He can see, this is the person who make allegation against me. Let me see him because he's there physically in court. So when a witness is physically in court, he has got perhaps, or at least we hope, he's got a lesser tendency to lie. So he's got perhaps more tendency to tell the truth because the accused who he is accusing again is there looking at him. But if he is in the remote, he is through the Zoom, he will find comfort in the fact that the accused is not in the same room with him. He may find comfort in not telling the truth or even lying. So these are, ladies and gentlemen, I thought I should bring it to your attention because these are matters that will affect you, your children, your relatives, not just people who are currently on trial, whether the cases are highly publicized or otherwise. These are cases, these are issues that will affect everyone. If we are not concerned about it now, it'll come back one day and it'll bite us without even we realizing. That is all I want to say. I don't want to be too lengthy about this. I apologize. I in fact have taken a bit of time. I want to open this to question time if you have any questions.
Hi Tan Sri. Hi Tan Sri. I'm Justin from Berita 757 Awesome TV.
Right.
Good evening. Okay, so Tan Sri, I have two questions for you. The first question, pada pendapat Tan Sri, adakah Hakim Colin Sequeira cuba untuk menjangkaui kuasa sebagai hakim dan mengabaikan prosedur yang dikeluarkan KKM dan Majlis Keselamatan Negara? Dan selain itu, adakah wujud desakan pihak tertentu dalam usaha menekan sesi perbicaraan bersama Datuk Seri Najib Razak? That's my first question. My second question, Tan Sri, timbul persoalan mengapa proses perbicaraan kali ini khususnya membabitkan Datuk Seri Najib seperti atau mungkin dimanipulasi pihak tertentu tanpa memandang kepada beberapa kes dahulu yang tidak dilaksanakan mungkin dengan tidak sewajarnya, khususnya isu bank negara dan sebagainya sebelum ini. Yeah. Those two is my questions. Thank you.
Alright. Biar saya jawab soalan satu persatu. Justin, saya rasa saudara, oleh sebab saudara tanya soalan itu dalam bahasa Melayu, mungkin saudara perlu saya jawabkan soalan ini dalam bahasa Melayu ataupun jawabnya dalam kedua-dua bahasa.
Boleh jawab dalam bahasa Melayu ataupun bahasa English.
Alright.
No problem.
Saya jawab dalam bahasa Melayu dulu. Di mana yang perlu saya akan jawab dalam bahasa Inggeris ya. Okey, soalan pertama ialah berkenaan dengan tindakan Hakim Justice Colin mengabaikan arahan daripada KKM berkenaan dengan status seseorang yang terlibat dalam COVID. Ya. Saya rasa Hakim Colin bukan sengaja mengabaikan, tetapi beliau ada tekanan-tekanan yang tertentu kerana kes 1MDB ini oleh sebab COVID telah berjalan dengan tidak begitu lancar. Ada pada masanya yang beliau terpaksa menangguhkan perbicaraan. Dari segi COVID sahaja saya rasa ada 2 atau 3 kali yang beliau terpaksa menangguhkan kes. Jadi ada tekanan kepada beliau Mungkin tekanan ini juga sebab kes SRC sudah pun habis, sudah pun naik ke peringkat rayuan dan rayuan pun dah habis. Jadi mungkin beliau rasa tertekan untuk menjalankan kes ni dengan seberapa cepat yang boleh. Okay. Walau bagaimanapun, soalan Cik Justin memang memang elok sebab kalau kita lihat daripada apa yang tercatat dalam Section 15A. Section 15A sendiri mengatakan bila kita nak guna pakai remote hearing ataupun hybrid dan sebagainya, it must be in the interest of justice. Jadi soalan sama ada seseorang hakim boleh mengabaikan, jawapan saya memang dia tak boleh abaikan larangan ataupun arahan KKM. Sebab ini adalah sesuatu yang akan melibatkan masyarakat umum, iaitu jikalau wabak COVID merebak, kita juga yang akan jahanam. Dia tak boleh abaikan. Jadi saya harap pada masa-masa hadapan, saya harap semua hakim-hakim akan mengambil kira. Kalau seseorang peguam atau seorang orang kena tuduh, dia katakan dia telah pun berdekatan dengan seseorang yang ada COVID dan jadi dia primary exposure bukan secondary exposure, saya rasa kita boleh siasat sama ada benda itu betul. Dengan senang saja, bukan susah. Kita tanya siapa yang dia kata dia expose, bila, dan kalau dia cerita bila dia terekspos, macam dalam kes saya dah bagi tahu di satu dinner di restoran nama China di hotel Hilton Central. Sekian masa. Siapa punya birthday, siapa yang hadir dan siapa yang kena COVID. Malam itu juga dia kena COVID tapi hari kemudiannya dia beritahu. Jadi kalau kita tahu ini benar dan kita tahu Tan Sri Syafi, Cik Farhan attended this, kita dah tahu, then we must give way. We have to give way because saya dan Farhan, we would have affected and exposed everybody else in our firm because dalam firma saya, semua dalam syarikat saya iaitu dalam firma saya iaitu yang terlibat dalam kes 1MDB, lebih kurang 90% of them semuanya akan berdamping berdekatan dengan saya. Jadi they all become suspect of COVID. So hakim harus mengambil kira perkara sedemikian. Sungguh pun ini amat irritating to the proceeding, but we can't do anything. Bukan kita minta nak kena jadi COVID, but this happens. Yeah? And you seperti yang saudara tahu, pada satu ketika satu tingkat sekali di Peguam Negara semuanya affected by COVID. Bukan dia orang minta nak jadi sedemikian, tetapi benda ini tak dapat dielakkan. Ya. Okey, nombor 2 berkenaan dengan tekanan. Cik Justin katakan tekanan sama ada tekanan ke atas hakim-hakim. Saya katakan begini Cik Justin, saya harap tidak ada apa-apa tekanan ke atas mana-mana hakim. Dan saya juga rasa mungkin tidak ada tekanan, tapi kalau ada tekanan, ia adalah sesuatu yang akan memudaratkan negara kita sebab sistem kehakiman akan berkecai, akan rosak dan kita tidak akan dapat lagi justice seperti yang kita selalu minta. Ya. Jadi dalam kes 1MDB ini, saya percaya Justice Collin dia tertekan sebab dia sendiri mengatakan kes 1MDB ini dah bermula semenjak 2018. Ya. Tetapi saya ingin tekankan sini juga ya. Umpamanya kalau kita pergi macam hari ini saya tahu di dalam kes Lim Guan Eng yang beliau sedang hadapi kes korupsi. Hari ini hari penghabisan. Next sambung bicara ialah pada bulan March April. Jadi macam tak ada apa nama ni anything in a rush. Okay. Lagi satu, kebanyakan saudara-saudari tidak sedar ialah begini. Bila kita hadir kepada perbicaraan Datuk Seri Najib, kita tahu banyak orang kena tuduh dalam kes-kes dadah masih merengkot dalam penjara menunggu tarikh untuk dibicarakan. Ada yang 2, 3, 4 tahun pun ada. Jadi kenapa orang-orang ni yang tidak boleh dibebaskan dengan jamin ataupun jaminan, walhal Datuk Seri Najib ada jaminan. Kenapa mereka-mereka ini yang merengkot? Yang mengikut sistem perundangan yang betul ialah kita bagi prioriti kepada orang yang tak ada bail. Tetapi kita percepatkan kes-kes VIP ni terlampau cepat. Jadi saya rasa ini adalah satu yang tidak adil. Saya tak mau katakan apa yang menyebabkan perkara ini berlaku sebab saya tak mau buat tuduhan yang bukan-bukan. Saya seperti saya katakan, saya harap semua hakim-hakim menjalankan tugas mereka dengan terus terang, dengan tidak ada berat sebelah. Tetapi saya terkilan, saya juga rasa heran kenapa banyak kes-kes yang serius yang tidak ada jaminan, orang kena tuduh masih lagi merengkot dalam riman.
Okay, thank you Tan Sri.
Thank you.
Thank you.
Anybody else? Ada apa-apa soalan?
Soalan Tan Sri.
Yes.
Haris dari Malaysia Kini.
Haris, yes Haris.
Tan Sri, since you said that hybrid ni tak ada dalam provision.
Yeah.
Are you going to maybe challenge in court, bring a challenge in court or anything about this, or this is just for the future improvement?
Well, as you know, dalam application kita for further and fresh evidence, the Court of Appeal, because we couldn't turn up because we were met with the COVID exposure, we couldn't turn up. And the court said, it doesn't matter, let's go through COVID. And mind you, this is a criminal matter. All right? Now, what is the difference between between hybrid and physical or full hybrid? Or full, full Zoom. Now, I oppose totally to hybrid because a good illustration is what happened in the SRC. My learned friends from the prosecution were before the court. They had the fullest advantage of audio visual. Their voice can be heard by the judges. They can hear the judges so clearly as compared to us. We were in the Zoom because we were told, okay, since you cannot attend, you attend by Zoom. So they had all the advantages. We had no advantage. Yeah. So, and there have been complaints, if some of you attended, where I raised my concern in open court by Zoom, and I said I couldn't hear Justice Wazir, for instance. And then I couldn't hear Datuk Sidambaram, for instance. I couldn't hear. There were portions of it that went silent. And there were portions of it that were blur, but we tried to make do with what we could hear. And of course, this is audio. The visual aspect, we cannot see what the judges are reacting to my submission. But whereas Datuk Sidambaram have got a 24/7 look at the judges. So to me, this is unfair. And we will certainly take this matter up to the federal court as part of our argument in the appeal that forcing us to do through hybrid was unfair, among many other reasons. So basically, I'm saying if you do a hybrid, we were restrained very much. We were restrained from capitalizing the human elements of audio and visual, whereas my opponent capitalized it to their maximum benefit against us. So where is in the interest of justice? Section 15A said, in the interest of justice. Where is the interest of justice? You compel a hybrid. Any other questions?
Hi Tan Sri, I'm Justin here from Berita 757 again. This would be my last question. Okay. Adakah ini hakim yang sama yang meminta Datuk Seri Najib untuk hadir ke mahkamah ketika Datuk Seri Najib bertemu Yang di-Pertuan Agong? Dan mengapa ini berlaku dan seolah-olah tindakannya membelakangkan institusi beraja?
Okay. Justin, I think you meant a previous episode before Justice Collins.
Yes, previous episode. Okay. Yes, correct.
Oh, okay. Where Datuk Seri Najib wanted to attend a function at the Istana.
Yes.
I think it was a function at the Istana in relation to an important ceremony. Yes, sorry. No, I'm just corrected. This is a matter, not ceremonial, sorry. It is a matter where the Yang di-Pertuan Agong wanted to interview members of parliament in relation to the vote of confidence. So he wanted to get the numbers in relation to which side the members of parliament lie so that he can determine who can be the Prime Minister. As you can imagine, this is a very critical matter. Absolutely critical matter. My client was split between attending that in a timely fashion and attending court. So he's got a court proceeding. So we attended the court ahead of time and we told the court that he has got to be in the bus or following the bus to go to the Istana on a designated time because the interview by the Yang di-Pertuan Agong was going to take place segment by segment and you cannot break the segment. But I think perhaps Justice Collins did not get the fullest impact of that mechanics of interview. And I think mungkin dia tersalah cakap where he said, whatever it is, it doesn't matter whether you're going to see the Yang di-Pertuan Agong or not. You come and see me first, and then you can go. So I think tersalah cakap. I don't think Justice Collins meant like that. I think he probably meant that why don't you come and tell me personally, in person, and then of course you can attend that meeting. Perhaps what he wants is a matter of decorum. But you know, my client could not. I mean, as much as he wanted to show decorum, we had to attend on his behalf to show that decorum because he had to be in front of the learned, in front of the Yang di-Pertuan Agong.
Tan Sri, Timothy from The Edge.
Yes.
Tan Sri, just it was reported today that you did attend Lim Guan Eng's trial.
Yes.
Just wanted to find out whether you face any obstruction getting into the trial today since your status is still orange and you're still under the HSO surveillance order.
Yes, I went in yesterday as well because we were ordered to go in. So I went and I showed to the what do you call it, to the guard yesterday. It was still orange, just like Datuk Seri Najib, still orange. But I chose to be responsible because I have lawyers who can do in a somewhat limited way because I am more prepared for the cross-examination of these witnesses. But my other lawyers, they are substantively prepared, but not as prepared as I am. But in the context of being responsible, not spreading the virus, because You know, Timothy, many people do not know this. If I am exposed, just like I was exposed in this case to my son as well as my guests by this particular datin who are confirmed COVID patients, and then I'm tested. 2 days later, I must test, and I did the simple test and the PCR test. Both says negative. Many people don't realize, why are you in the quarantine then if you're negative? The reason why you are still in the quarantine is because it can develop what they call it, the gestation period is at least 4 or 5 days. You can develop into positivity during that period of quarantine. So this is why you must stay away from the public. But because we were ordered to be there, I presented myself, but I did not go up. This time I did not go up to the court. My client went up. The first day I went up, my client went up. And I felt bad about it because I don't know whether I've done damage or my client has done damage, because, you know, we do not know whether we will turn positive or not. Thank God, my second test is also negative. My client's test is also negative. But we have to be responsible. We also must have the social distance, because that is demanded of us if we want to fight this COVID-19 seriously. And that is my message. So today, I turn up. You must know I turn up earlier at 8:30 because I've got my own case, my own trial before Justice Jamil in court number 4, High Court, criminal. I was there earlier. Many people don't realize this. They don't want to quote this, but they get excited when they suddenly see me on the same day, 2 hours later, accompanying a witness into Lim Guan Eng's court, because I have been instructed by this witness to do watching brief for him if and should he be called. So I attended. Now, I attended because I have got the comfort that I am clearly out of the quarantine period, because MySejahtera does not know how to calculate and ask the right question. I'm criticizing MySejahtera because it is such a weak system, does not know how to calculate, does not know how to ask the right question. You see, in a statistics, in a program like this, if you ask a rubbish question, you get rubbish answer, and then you'll get a rubbish conclusion. That's what happened to me. If you look at MySejahtera, it says until 22nd. Whereas my quarantine has finished on the 16th. If they calculate it from the 6th, 6. Yes. That's my answer.
Thank you, Tan Sri.
Thank you.
Tan Sri, Johnny daripada Utusan Malaysia. Tan Sri, nak minta komen sikit tentang perkembangan rayuan kes SRC yang baru ni kat Mahkamah Rayuan tu. Kan Tan Sri pihak dah kemuka rayuan tu. So apa perkembangan kes tu? Dah kemuka rayuan, dah file rayuan ke belum? Itu pertamanya. So adakah bukti baru tentang JT atau Aziz tu akan dimasukkan dalam bukti dalam rayuan di Mahkamah Persekutuan?
Yes. Terima kasih. Saya tak dapat nama tuan tadi.
Juwani.
Ya, sorry. Juwani. Okey, Cik Juwani, macam ni. Seperti yang Cik Juwani sedia maklum, kes SRC di Mahkamah Rayuan berlalu dalam 2 hari, iaitu 7 dan 8. 8 ditetapkan hanya untuk keputusan. 7 hari bulan ditetapkan oleh sebab satu permohonan yang kita buat secara mendadak dengan segera, iaitu permohonan untuk memasukkan keterangan baru dan yang tak pernah kita terima sebelum itu. Ya. Now, jadi kita file beberapa hari sebelum 7 bulan. Jadi pada 7 bulan dia nak dengar juga, sungguh pun kita ada COVID. Dia nak dengar, jadi kita presented from our side. Jadi dia tolak. Okay. Dan pada 8 bulan the next day, they read out a written judgment of about 300 odd pages. Okay, nothing was mentioned about our additional evidence being rejected. Yeah, so it is quite obvious that judgment has been written. That's why they want to deliver it on the 8th. Okay, but they heard us on the 7th, and they rejected, and they gave reason. We are not happy with the reason at all. Okay, so we are appealing. Kita membuat rayuan atas perkara yang berlaku pada 7 bulan, iaitu rayuan untuk rayuan kerana permohonan kita ditolak untuk keterangan baru. Yang itu satu. Oleh sebab ada 3 kes, kita buat 3 rayuan yang sama. Dan pada 8 bulan pula, bila kita kalah dalam rayuan, kita juga buat rayuan terhadap keputusan rayuan 3 kes tu. Jadi ada 3 rayuan. Jadi semuanya 6 rayuan. Kita akan tulis kepada Mahkamah Persekutuan untuk mendengar rayuan pertama dulu, iaitu berkenaan dengan penolakan keterangan-keterangan yang baru dan fresh. Dan untuk maklumat Juwani, kita juga ada desas-desus information yang sudah datang kepada kita, ada lagi keterangan lanjut yang kita baru dapat tahu, yang disuppresskan dan tak diberitahu kepada kita oleh mana-mana pihak maupun pendakwaan ataupun MACC ataupun polis. Sekarang kita dapat tahu. Jadi itu juga akan kita masukkan dengan kepada Mahkamah Persekutuan dalam satu lagi permohonan untuk keterangan lanjut dan baru.
Datuk Tan Sri boleh ceritakan keterangan baru tu pasal apa? Boleh ceritakan?
Yang belum kita masuk.
Belum masuk ya?
Yang tu kita tak boleh bagi tahu sekarang sebab kita nak confirm dulu. Kita nak confirm dulu sebab kalau tidak kita cakap main atas angin dia. Ya? Ya. Ada apa-apa lagi soalan? Maybe last one question ke?
Tan Sri Marfika bernama yang Iwan tadi dah file ke?
Sorry, siapa ni?
Marfika bernama.
Yes, bernama, yes.
Okey, yang rayuan tadi dah file ke?
Semua 6 rayuan dah file.
Bila Tan Sri
Kita dah filekan pada 8 Disember 2021 untuk rayuan utama, iaitu rayuan berkenaan dengan keputusan 8 bulan. Okay. Dan bagi keterangan lanjutan dan baru, iaitu yang diputuskan pada 7 bulan tu kan, kita dah file pada 15 Disember. 3 rayuan juga. Jadi semuanya dah file.
Petition rayuan SRC. Dah file?
Yes. Okay,
untuk petition SRC dah file ke belum?
Okey, soalan daripada bernama ialah sama ada kita telah filekan petition rayuan. Petition rayuan seperti yang saudara-saudari maklum ialah sebab-sebab kita merayu dengan cara terperinci. Okey, petition of appeal ni kita hanya perlu mengfilekan bila kita terima rekod appeal bersama-sama dengan keputusan mahkamah yang diserah secara formal. Sekarang keputusan pun belum diserah kepada kita secara formal. Sungguh pun kita tahu apa dia keputusan dan sungguh pun banyak orang sudah pun dah terima nak senaskah keputusan, tetapi secara formal ianya kami belum terima bersama-sama dengan rekod rayuan. Selepas terima kita ada 10 hari. Kita ada 10 hari untuk mengfilekan petition of appeal.
Country yang Haris from Shikini ya.
Ya Haris.
Yang apa ni keterangan baru tu bila expect keterangan yang lagi baru tu, the latest one, when do you expect to file? Then
we are hoping within 2 months. We are hoping within 2 months but you know, sometimes nak cari dokumen ni dalam keadaan banyak authorities ataupun pihak-pihak berkuasa yang dengan secara aktif menyembunyikan daripada kita, memang susah kita nak pecah jalan untuk mencarinya, tetapi insya-Allah kita akan dapat. Kita harap dalam jangka masa 2 bulan.
Thank you, Tan Sri.
Thank you. Jadi kalau tidak ada apa-apa lagi soalan, ya, tidak ada apa-apa soalan ya. Jadi dengan itu saya mengucapkan ribuan terima kasih kepada saudara dan saudari yang telah pun melapangkan masa untuk menghadirkan diri, sungguh pun secara Zoom, tetapi ini memakan masa daripada keluarga dan juga masa untuk kendiri saudara. Jadi saya mengucapkan ribuan terima kasih. Assalamualaikum. Terima kasih.
Recording stopped.